Armand Derfner was born in 1938 in Paris, France. He earned his undergraduate degree from Princeton University in 1960 and was a recipient of a Woodrow Wilson Fellowship. He then earned his LLB degree from Yale Law School, where he was an editor of the Yale Law Journal and a member of Order of the Coif. Mr. Derfner served the Lawyers' Constitutional Defense Committee in its work in Jackson, Mississippi in 1968 to 1970, and the Lawyers' Committee on Civil Rights under law in Washington, D.C. from 1971 to 1974. He has also served the Joint Center for Political Studies in Washington and as a visiting professor of law at American University. Mr. Derfner's writings include Racial Discrimination and the Right to Vote and Development of the Franchise, 1957 to 1980, Voting Rights in America, published in 1992. Mr. Derfner repeatedly testified before committees of the United States Senate and House of Representatives between 1967 and 2009 and was directly involved in the 1982 amendments to the Voting Rights Act. In the courtroom, Mr. Derfner was on the front lines of the legal history of voting rights as a part of the legendary legal teams that included Jack Greenberg, Joseph Rao Jr., Nicholas Katzenbach, John Doerr, and others who were the seminal legal advocates for voting rights, dealing with race, voting, and redistricting. Mr. Derfner argued or was a member of the legal teams that briefed and or argued most of the seminal cases interpreting and applying the critical sections of the Voting Rights Act, including Allen versus State Board of Elections, Perkins versus Matthews, City of Petersburg, Virginia versus United States, City of Richmond versus United States, Blanding versus DuBose, McCain versus Librand, and NAACP versus Hampton County Elections Commission before 3-judge federal courts and the United States Supreme Court. We've come to Charleston, South Carolina to have a conversation with Mr. Derfner at his home library on the subject of the right to vote as a capstone of the 2 great civil rights laws passed in 1964 and 1965. As is true of the study of civil rights generally, the legal history of voting rights is as old as our country. Any full history begins there, as Alexis de Tocqueville reminded us when he wrote of democracy in America in 1835. And we could begin our legal history with the Supreme Court's decision in Dred Scott. But we have begun the text of the legal history of voting rights in a way that will emphasize the work of Armand Derfner and others to include the right to vote as a part of the promise of the civil rights movement. So, Mr. Derfner, let's begin our conversation today with the beginning of our text, the Supreme Court's decision in Smith v. Allwright in 1944. Looking back, what is the essential significance of Smith v. Allwright in propelling the legal history of voting rights?
Well, up until Smith, because the Democratic Party, being discriminatory, had the sanction of the Supreme Court and was so successful, it was like the whole process of registration or voting was bottled up. It didn't matter whether somebody a black person could register or pay a poll tax or whatever, because it was useless. Well, once Smith said the Democratic Party could not keep blacks out of the primaries, it sort of turned things loose. And so a lot of black people started trying to register, started complaining about and fighting against literacy tests, poll taxes, organizing, etc. And remember, this is 1944. So 2 other things were happening right about that time. World War II was ending, and a lot of blacks who had been in the Army, veterans, were coming back to southern states and not willing to put up with what they had put up with before. And Jackie Robinson came into the National League. And those 2 things together meant that the late 1940s, with the white primary gone, were really a time of ferment.
The southern states' response to Smith v. Allwright was the pervasive use of so-called citizenship tests and understanding tests as a scheme to disenfranchise black voters. In the early 1960s, Judge John Minor Wisdom writes for a 3-judge federal court in United States versus Louisiana, striking down these tests both as conceived and as applied. His opinion is a detailed constitutional history so as to reveal the purpose of the Southern state strategy. What was the significance of his ruling in United States versus Louisiana?
Louisiana, about the time the case was filed, realizing that their old test was going to be thrown out, came up with a new test that was in fact fair. I don't remember all the details, but it was a test that was going to be administered fairly, and it was a real literacy test, like let's say the New York State literacy test. And so they said, therefore, everything is okay. And what the court said, and this is really sort of what became important 60 years later, although the Supreme Court didn't think so, in Shelby County, the Supreme Court said, wait a second, you're saying that from now on, everybody will take a fair test, but you're proposing to leave on the rolls everybody who qualified as a white person under the old non-test, and so you're preparing to bring into the modern day and carry forward the dishonest legacy of the past. And so the lower court, the district court, Judge Wisdom, rejected it. And when it came to the Supreme Court, I think Justice Black wrote the opinion. And he wrote something that was really critical. He said, we bear in mind that a court has not just the power, but the duty to not only to both eliminate the effects of the past and prevent discrimination in the future. And so what that case did is it said, you can't just start today and say, well, what was then, that was yesterday. We're starting clean now. You have to recognize the impact of the past, and it doesn't go away by itself.
As U.S. versus Louisiana evolves, the First Amendment moves center stage in Selma, Alabama. Our text describes the history of the events that led to Judge Frank Johnson Jr.'s decision in Williams versus Wallace, that a mass march from Selma to Montgomery represented a peaceful effort on the part of black citizens to exercise a classic constitutional right. That is, the right to assemble peaceably and to petition one's government for the redress of grievances. How important was Judge Johnson's decision in Williams versus Wallace to the eventual passage of the Voting Rights Act and to the idea that the right to vote rests in the First Amendment?
It's really at the heart of everything. It's at the heart of everything historically because it led, in a sense, to the Voting Rights Act. When right after that, especially after Viola Liuzzo was shot by a Klansman on the way home from the march, and President Johnson called a joint session of Congress and said, we shall overcome. All those events in Selma and the march that crystallized it were part of the history, but also the whole notion is that the right to vote is the most expressive thing. It's not just functional. It doesn't just elect people. It is the way we express ourselves. And the civil rights movement had really created a new First Amendment. Up until the 1960s, the First Amendment had some limited application, mostly for Jehovah's Witnesses who were going door to door, or people, isolated speakers in parks who wanted to be able to complain about whatever. But the whole notion of mass movements was not really the subject of constitutional law. And it was the civil rights demonstrations of the early 60s that created a whole new First Amendment. And Williams versus Wallace reflected that, because in the Selma March, they closed down Highway 80, a United States highway, a U.S. highway. And Judge Johnson recognized, in a sense, that the First Amendment is a reflection of what the most vigorous speech and issues are. And in a sense, the amendment follows the emotions of the day, and the amendment follows the needs of the day.
So you see Williams versus Wallace as a lesson in the scope and relationship of the First Amendment's freedoms.
I think it was in advance of its times, but the fact is, in fact, the U.S. Supreme Court just about a year or so ago, or a couple of years ago, maybe last year, revived the petition clause. And so now people are thinking about it more. And in fact, the petition and the speech clause are now viewed as two parts of the same right. And the Supreme Court, in this case from Philadelphia, sort of just a minor case, said, well, free speech is people talking to each other, talking where they feel like talking. But petitioning is when you're trying to talk to the government. And so I think people are coming to recognize that the right of petition is something that's, if anything, more at the heart of the First Amendment even than ordinary free speech.
In fact, you had a personal experience that still means a lot to you as you look back on Williams versus Wallace.
In 1968, when Dr. King was murdered, you remember there were riots, there were demonstrations, there was tumult all around the country. I was in Mississippi at the time. There were many demonstrations there. They were entirely peaceful. There was one in particular in Holly Springs, Mississippi, a small town halfway between Oxford and Memphis. And in Holly Springs, what happened was the town, people would meet in church and then go out and march. They'd meet in church and they'd go out and spontaneously march. These were very orderly marches. But the city passed an ordinance, and it was a very careful ordinance. It didn't say you can't march. It didn't say you need a license 2 weeks ahead. It was the most unrestrictive ordinance you could ever imagine. All it said was, if you're going to march, you just have to tell us, I think you had to give us an hour's notice and just tell us where you were going. Which under any circumstances would be upheld. It's perfectly normal. And in fact, it was copied from an injunction that had been entered in some other city that had a bad ordinance. And the judge said, okay, I'm not going to let the city restrict you. I'm going to say that the city has to allow any march as long as you get an hour's notice and tell you where you're going. So what we had we were challenging this ordinance because a bunch of people marched, got arrested. It was a very orderly march. In fact, they stopped at red lights along the way. So we tried this case, and I thought, surely we were going to lose the case because it's as unthreatening, as unrestrictive an ordinance, it's as protective of First Amendment rights as you can imagine. But this all came in the days after Dr. King was killed. We tried the case for a week, and I remember I went to the post office about a few weeks later, one Saturday morning, and I opened the post office box, and there was the opinion. And as I read it, I saw Judge Cady of Mississippi, Northern District of Mississippi, appointed by LBJ, had ruled for us. He'd said that while this ordinance might be valid under another time, because of the extreme situation, extreme provocation of the time, the First Amendment has to reflect that. And he cited Williams versus Wallace. And so I actually cried when I saw that opinion. And it's just like what you say. Williams versus Wallace really came to life.
Now the story turns to the passage of the Voting Rights Act itself, and your first voting rights case before the United States Supreme Court, Allen versus State Board of Elections. Before we get to the case itself, what was the fundamental purpose of the major sections of the Voting Rights Act?
The Voting Rights Act, first of all, you remember it was passed after 3 previous voting acts had failed. They all depended on trying to streamline the judicial process, and it became clear that the southern states were faster than that. J.P. Coleman said any legislature could pass a new law faster than the courts could throw out the old one. So the Voting Rights Act was designed to just take it all out of their hands. So Section 4 suspended literacy tests and similar devices in states that had a proven bad record. And there was a formula that was based, that would show which states had a bad record. Other sections said that when I say it suspended literacy tests, Section 4 said that the local registrar was supposed to register people without making them show that they were literate. Okay. It also authorized the Justice Department to send federal examiners to any county where the local registrar just wouldn't do it. A lot of local registrars in the South said, hell no, I'm not going to do it. And so in that case, those cases, the Act authorizes the Justice Department to send federal examiners, that is mostly federal civil servants, down there to become the registrars. So that it didn't matter what the local registrar did or didn't do, those people were getting registered if they were qualified under state law without having to be literate. And then part of that also was they could send federal observers to watch elections to make sure that they were fair, not intimidating, etc. And there were a number of other provisions. But the main other provision, which didn't seem quite so front and center at the time, was something called preclearance, and that was in Section 5. And it said that in those places, which was basically most of the southern states that had their literacy tests suspended, they would have to pre-clear any voting provision before they changed it, because Congress knew that quick changes were how the South escaped the Constitution.
The court had already ruled in South Carolina versus Katzenbach that Section 5 of the Act was constitutional.
Yes, in South Carolina versus Katzenbach, the court had ruled that Section 5 was constitutional, with the dissent by Justice Hugo Black of Alabama, who had been very strong for school desegregation, but by now had either changed some of his views or this was different. He said he thought it was unconstitutional to make states go hat in hand to get preclearance, hat in hand to the government to get preclearance for their anytime they just wanted to pass a law. So Katzenbach said the covered states could be made to have to wait to enforce their new voting laws until they got preclearance by showing that the new law was not passed for discriminatory purpose and would not have a discriminatory result. The question was, what does that mean?
And then comes Allen versus State Board of Elections. What was the significant relationship between South Carolina versus Katzenbach and Allen versus State Board of Elections?
And when we came to Allen, that was a controversy about several types of new laws that had become the currency in the South after the literacy tests were suspended. What happened was Section 5, probably most people thought that Section 5 was going to be needed to stop states from evading the literacy tests, coming up with new schemes to get around the literacy test. That didn't happen, partly because the states that wanted to evade the literacy test, the federal government would just send in the federal examiners. And so the suspension of tests or devices, the end of literacy tests, that succeeded almost overnight beyond anybody's expectations. And literally hundreds of thousands of people, millions of people, got registered very quickly. Well, what happened then was that the southern states fell back and resorted to new tactics. So instead of preventing black voters from voting, they started thinking about, well, how do we make sure those votes don't mean anything? How do we prevent black candidates from winning? Or how do we prevent the black voters from having any influence? And so, for example, they came up with things called dilution. That is, they would shift from district elections where blacks might be in the majority in some parts of town, whites in another part of town, but they might say, the city would say, well, let's go to at-large elections, meaning everybody gets elected citywide, and in those cities what that meant as a practical matter was that whites would win all the seats.
And so you successfully challenged these schemes for the first time in Allen.
The importance of Allen was what would Section 5 cover? And what Mississippi argued, and frankly it had some appeal in terms of what Congress probably had in mind, was that it was just covered efforts to get around the literacy ban or literacy suspension. Because Section 5 said basically that any voting standard or qualification or practice or procedure relating to voting has to be pre-cleared. And the question was, what does any standard or practice or procedure relating to voting mean? And so Mississippi said, well, that just means it's related to Section 4, which is about literacy tests, so Section 5 must be about literacy tests and only things about literacy tests. And we argued no. And the case involved a number of things that were not literacy tests. One was a redistricting, one was a change of office from electing to appointment, one was new restrictions on running as independents. So these were basically the political process, but not the actual voting. And the Supreme Court agreed with us and said, whatever may have been in the minds of, whatever may have been in the expectation of Congress, the words are as broad as voting itself, and the words are so broad because Congress knew that the schemes that people would come up with were beyond what people were thinking at the time. And so Section 5 was a way of Congress saying, we don't know what you're going to do, southern states, but we know you're going to do something. And this statute is worded so broadly that whatever you do, whether we can now imagine it or not, whatever you do, you'll be covered by it. And in effect, we know you're going to try something. Before you do, we're going to head you off at the pass with this statute by requiring you to come and get permission first.
What if Allen had gone the other way? Why was this decision so important early on?
Because all these tactics that people would have liked to use or started to use in the late 60s, most of them would have gone through. And what Section 5 did was really to help change the regimes in the South, change the way of thinking. Because, yes, there were hundreds and thousands of objections over the years, but they're nothing compared to the things that southern states and counties and cities didn't even try to do because they knew they'd never get pre-cleared. So I think Section 5 just had an enormous consequence.
Now, I know that there's one other aspect of Allen as a seminal case that you believe is important.
There's another great thing about the Allen case which shows how important it was that the Warren Court was in place at that time. Before we could even get a decision, as you know as a law professor, there's a question of, is there a private implied cause of action in the statute? In other words, when statutes often create rights, they don't necessarily say, and people who are aggrieved by this are entitled to sue. Well, in that, and nowadays, in fact, the law is that, according to the Supreme Court of these days, that if the statute doesn't say you can sue, you can't sue. Well, the Voting Rights Act didn't say that private individuals could sue for the protection, to enforce the requirement that states and cities go ahead and pre-clear. And so the very first question we had to deal with was, is there an implied right of action? And the court held, yes, there's an implied right of action because there has to be in order to carry out Congress's noble goal. And so the court understood in those days that when Congress was passing these laws, these civil rights laws, these weren't just some piece of legislation that they tossed off. These were at the heart of what was necessary to make the country tick and make us one nation if we could.
After your success in Allen, you become involved in a case called Perkins versus Matthews, a case from Canton, Mississippi. You've said to me that Perkins revealed the real impact of seemingly minor changes by the southern states in their voting schemes.
What Perkins involved, Perkins was Ernest Perkins, and I think Matthews must have been the mayor of the city of Canton, which is this small town about a half hour outside of Jackson, Mississippi. And they made some changes in the election, and they just didn't bother to pre-clear them. It was a little complicated. So when we went to the Supreme Court, what really caught everybody's attention, I think it caught people's attention, was the major change was they moved a polling place. And on one hand, you couldn't think of anything more insignificant as a voting change than just moving a polling place. Well, gee, if this law makes it impossible for a tiny town to move a polling place, well, maybe the law is way too broad or something. But what brought people's attention back was, where did they move the polling place? Well, they moved it from a school or some other public building to the old jail, no longer in use, but it was a jail in which countless numbers of black voters in that town had been jailed illegally, had been beaten up. It was a jail. It was, frankly, for people in Canton, for black people in Canton, it was a place that held horrible memories, and for some of them, it was just plain scary. And everybody could see, on one hand, well, it seems like a tiny change, but on the other hand, which is just what the Supreme Court was saying, and just what Section 5 meant, even something that seems innocent can be egregious.
So a purposeful intent to dilute the tendency of black citizens to actually vote by this seemingly innocuous act is seen by Congress as the essential reason for Section 5's protections.
Yeah, and so these are registered voters, and the town says, well, we're not trying to stop anybody from voting, but they're doing something that will make that happen. And here, interesting thing, I had dinner last week. I had dinner with some federal judges, one of whom was a retired judge and had been a lawyer for a good number of years in the South. And he said, oh, I remember the Voting Rights Act when it first came in. He named Perkins versus Matthews. He didn't name Allen, and he didn't name South Carolina versus Katzmack. Perkins versus Matthews was the case he named. That's the one that stuck in people's minds because they could see right in front. And I have a picture of the entrance to that old jail.
Modern history has tended to either forget or obscure the difference between at-large elections and precinct or ward elections. What was the specific issue raised by the Southern state strategy of at-large elections when the Voting Rights Act was passed?
I told you earlier that there became to be an epidemic of at-large elections. Because what would happen is, as I say, a city might have a population of, say, 40% black. And with residential housing segregation being pretty common, it also was true, at least in the South, and probably generally then, less so today, white people wouldn't vote for a black candidate. And so there was something called racial block voting or racially polarized voting. So what that meant is that if you had a city and you had let's say a district where blacks were 75% of the population in that corner of town, well, they'd be likely to, those voters would have the ability to select or have the most influence in who's going to be the council member from that district, okay? And so it might be a black person, okay. If you shift to at-large elections in the whole town, then instead of having 75% black here and 75% white somewhere else, you've got 60% white and 40% black in the whole town, and all five, let's say if there are 5 city council members, all 5 are elected by the whole town. So everybody, all the officials are elected by this same 60% white electorate. And what that meant in a lot of these southern cities and counties and so forth was that there were no blacks on the council or ever going to get on the council because at-large elections would prevent that from happening.
How, if at all, did the Richmond case expand your efforts to challenge vote dilution?
In 1960, there was one city in the United States of America that had a majority black population. It was Charleston, South Carolina. And what happened because of that, the city started annexing territory. Let me go back a step, because as cities became blacker, white people started leaving, or as white people started leaving, cities became blacker. There was something called white flight. As blacks started moving into new neighborhoods, white people from those neighborhoods would fly away into the suburbs. It affected school desegregation, it affected housing segregation, etc. And it affected voting, because cities became blacker, and so you might have a city that was majority black or about to become majority black. Well, so what would the white, I hate to use the term power structure, but that's what it was. What would the white governmental body do? Well, what you do is you annex territory, you expand the boundaries so that some of the white people who left, who are no longer part of the city's population, well, they're back in the city's population. So when you were about to have, or maybe did have, a black majority, which might result, especially if you had at-large elections, it might suddenly result in electing a number of black council members. Well, the way to prevent that was to expand the territory to increase the population and bring some of those white suburbanites into the city population. And so with the at-large elections, you saved the city from starting to have some black council members, and you'd guarantee, in effect, that you'd have an all-white city council again.
And that method of vote dilution leads to your involvement in a series of cases, specifically the City of Petersburg case and the City of Richmond case, raising the issues of annexations coupled with at-large elections.
In Petersburg, here comes the annexation. Petersburg had just become majority black city. Petersburg is a city about 30 miles down the road from Richmond. It's where Virginia State College, or now Virginia State University, black state school. A lot of black faculty, so there's a big black population. And as I said, it became a majority. City moves to annex territory. Now, there are a lot of valid reasons for cities to annex. You want to increase the tax base. You want to grow a whole bunch of, and so what happened in that case is the court, Justice Department took the position, we took the position, the lower court took the position, and eventually the Supreme Court took the position by affirming the case that if there's no discriminatory purpose here, there's still a discriminatory effect, because you're turning by bringing this annexation in, you're turning from a black majority to a white majority. Now, oftentimes that wouldn't make a difference. If people didn't vote along racial lines, well, it wouldn't make any difference. People get elected, whoever gets elected. But if you're electing at large, that means every single council member is now going to be elected by a white majority instead of a black majority. So what happened was, Justice Department, Court, and Supreme Court said, we're not going to stand in the way of an appropriate city function and an expansion that has economic benefits, etc., but we're going to make you mitigate the effect of that, because we're not going to let the entire city council ride on that. And so the court justice said, we will allow the annexation if you will go to single-member districts. Because once you go to single-member districts, the difference between whether it's a little black majority or a little white majority, it might affect one seat, but by and large, each district is not going to be much affected. Whereas if you have at-large elections in which everybody in the city votes on all seats, the difference, and if you have at-large elections, the difference between white majority and black majority is all or nothing. And so the consequence of Section 5 was to say you can have the legitimate city change, which is the annexation, but you've got to mitigate it. You can't have it result in an all or nothing effect on voting. And that became the pattern for the Richmond case too, although there's another situation in Richmond. But there was one critical part of that. In order to get that result, we had to show that people voted along racial lines. Because if people didn't vote along racial lines, it sort of wouldn't matter. If everybody voted just according to personal preference, political party, whatever, then it wouldn't matter whether you had black voters or white voters. But if people vote along racial lines, then the race that's in the majority is going to get more votes, and the race that has more voters is going to get more votes, and the race that has fewer voters is going to get fewer votes. In other words, if you show that people vote along racial lines, that voting is, as they call it now, racially polarized, then population is the only thing that matters.
And you therefore used a bivariate analysis in Petersburg.
Petersburg was the first case that established the beginning of a method to do it and established how critical that issue was. And the method we used was very simple. It was almost, you could say it was primitive. Petersburg had a lot of precincts that were either all white or all black, or virtually all, 95, 98%. What we did is we just analyzed in those precincts who got the votes. And we showed what we called it mirror image precinct analysis.
How, if at all, did the Richmond case expand your efforts to challenge vote dilution?
The Richmond case was very much like Petersburg in the setting. That is, you had a majority black city annexing territory, and the end result was that they were allowed to keep the annexation, but had to go to single-member districts. And the interesting thing is that initially, when the Supreme Court first decided the case, there was a finding, or there was that evidence of discriminatory purpose. I think I told you about the city official and the county official who got together and schemed about bringing in what they call leadership-type people. And the Supreme Court, in its opinion, said very categorically something that people use all the time now. A governmental act done for a racially discriminatory purpose has no credentials whatsoever. And that's a really important thing for them to have said. And that would have stopped the annexation, except that Richmond then was given the opportunity to go back and sort of redo the annexation and show that there were actually economic benefits from it. And so they were able to keep, as in Petersburg, get the annexation, go to single-member districts. The funny thing is that when they went to single-member districts, by that time the population had shifted a good deal, and the first thing that happened was they elected 5 black members and 4 white members on the city council, and city council in Richmond elected the mayor, so Richmond got its first mayor. The capital of the Confederacy became a city with a black mayor in about 76 or 78.
You see 1972 as a watershed, perhaps adding the court's Richmond decision in 1975 as being in accord with Petersburg. Could we talk for a moment about that point in the court's view of voting rights?
In a sense, it was almost the high point of the civil rights and voting rights commitment by the Supreme Court. You remember we talked about the Warren Court, and Chief Justice Warren and Abe Fortas, who was one of the strongest civil rights justices, both left in 1969.
And a new era now emerges with President Nixon's appointment of new justices to the United States Supreme Court. Our text describes two cases, the Dunn case and the Ferguson case. Why were these cases significant?
So the Dunn case was really part of the high point, let's call it 1973, because that's the beginning really of the Rehnquist influence, or what I would call the Rehnquist court and the scaling back of the right to vote. So in, I would say, 1973 or thereabouts, along comes the Ferguson case. And in Ferguson, what we had was Mississippi had a different rule, not how long you had to be a resident, but how long ahead of time you had to register. And the Supreme Court in Dunn had said, well, there's no reason that anybody should have to wait, and so you should only have, the only residence requirement should be whatever is necessary for the clerks to get the work done of getting the ballots ready. So in that case, it was 30 days. Later, the Supreme Court said, well, maybe 50 days if the clerk really needs the time. Well, Mississippi had a rule that said you had to be registered 4 months before the election. In other words, they closed the books 4 months before the election. And that also was a holdover from the old disfranchising days. So we filed a suit, Ferguson versus Williams, and the interesting thing was not only that we won that suit, but in the course of it, in the, as I recall, while the suit was pending, an election was coming up, and we applied to the Supreme Court, and it was, I believe it was Justice Brennan, who gave us an emergency order allowing Ferguson and anybody else who had registered, I take it back, you could register anytime you wanted, but unless you were registered 4 months ahead of time, you couldn't vote. So if you registered 3 months ahead of time, even though the clerk's office was still working away, you couldn't vote. There was no reason at all for it. And Justice Brennan entered an emergency order saying that anybody registered in that period of time, up to, say, 30 days ahead of time, could cast a provisional ballot, and it would be counted once the case was decided, or not counted. If we lost, we were certainly going to win. And that was, there was two parts to that. First of all, it showed that the court was still recognizing the expansion of the right to vote. And secondly, the court was really a place you could go to get some obvious relief that the Constitution entitled you to. The notion that we could go to a justice, the circuit justice, happened to be Justice Brennan then, and get an order like that, that was just priceless. And I've kept that attitude, and so sometimes I think we ought to be able to go to the Supreme Court, and it's what's the good word? It's like a dash of cold water to realize that many of the people on the court today don't have those attitudes toward the Constitution or the right to vote.
The Voting Rights Act was renewed in 1982. Could you tell us about the three pieces of that act and the position of a new Reagan administration?
You remember I mentioned that the act was initially passed, some of its provisions, for only 5 years. It was extended 5 more, and then in 1975 it was extended for 7 years, so it was going to come up in 1982. It was clear that it needed to be extended again, meaning Section 5. But also what happened is the Supreme Court in 1980 decided the Mobile case, saying that you couldn't get relief for dilution cases, you couldn't show an equal protection violation, the classic kind of case, unless you showed discriminatory purpose. And we thought that needed to be corrected. You couldn't correct the Supreme Court's holding on the 14th or the 15th Amendment, but there was another section of the Act, Section 2, that also said no discrimination, and the Supreme Court in Bolden had said Section 2 means the same thing. You have to prove discriminatory purpose. We could change that through a statutory amendment. So that sort of added to the burden of what we had to do. The third thing was that the language minority provisions, which had been added in 75, entitling people to information in foreign languages, such as in Texas or Arizona or California, a lot of Hispanic people, and other languages, which really was the first time that people with other languages really had the full-fledged right to vote. Because if you can't get the information, how are you going to exercise it? So by 1980 or so, 81, we had this sort of bigger task to do. The Reagan administration turned out to be the biggest roadblock of trying to get something done. In the end, frankly, we were able to get a strong bill through that did all three things. Amended Section 2 to create a cause of action notwithstanding Bolden and not requiring proof of purpose, extending Section 5 for 25 years, and extending the language provision for 25 years. And despite the administration's opposition and the Justice Department's opposition, we won the bill by something like 385 to 20 in the House and 85 to 8 in the Senate. Those may not be the exact figures, but it was of that magnitude.
The Blanding case and McCain versus Librand are especially important for their general re-emphasis of the Voting Rights Act. And I'm going to be specific here. The purpose for which it was enacted, the ongoing decisions necessary to sustain the enforcement process, the tactics of the southern states to thwart the act's remedial purpose, and the necessary scheme developed by the Justice Department and the U.S. Attorney General in response to its ongoing experiences with southern state resistance. Why were these cases especially important regarding the continuing use of what was called the discriminatory purpose standard as a southern state argument? And how did these cases strengthen Section 5?
Edgefield County is the classic old South Carolina county. 10 South Carolina governors have come from Edgefield County, including Strom Thurmond and including Pitchfork Ben Tillman. Well, Edgefield County by the 70s was majority black and yet had never had a black person on the county council. It's a rural county down near Aiken and Augusta, Georgia. So I filed, with some help from others, including Lachlan McDonald of the ACLU, filed a lawsuit in 1974 challenging the at-large system in Edgefield County. And at that time, there was a theory that because, although it was at large, they had residence districts. You had to live in a certain part of the county, but you were still elected at large. It was a theory that those, if they were severely malapportioned, that might be unconstitutional. The district judge ruled in our favor. So we won the case. Edgefield County appealed, and the Court of Appeals reversed. So we had lost the Edgefield County case. Then we proceeded with a traditional at-large case along the lines of Petersburg, that is showing under what was called the totality of the circumstances, under a case called White versus Register, which I'll come back to, that if the circumstances overall are such that black voters are not able to participate effectively then in an at-large system because of historical discrimination, because of poverty, because of tactics of the county, that you can dismantle the at-large system. We tried that case in 1974, and the case went for 6 years without a decision. The district judge, who was a very conservative judge, heard the case. We tried it for 3 weeks, I think, and he just wouldn't issue a decision. We would write him periodically and say, we don't have a decision, there's another election coming up. Years would pass, years would pass, years would... Finally, in 1980, in the spring, here comes a decision from the judge. And unbelievably, he ruled in our favor. This is a judge who sat on the bench for 20 years and never once issued a decision upholding a civil rights claim for black plaintiffs under the Equal Protection Clause or any of the statutes. Never once. This time he did. He said he had seen in this county evidence of a kind he had never seen before. We won. We were jubilant. We were jubilant. The date, as I recall, was April the 7th of 1980. Well, 5 days later, along comes the Supreme Court decision in Bolden, City of Mobile versus Bolden, saying it's not enough to have a totality of the circumstances to show that at-large elections are unconstitutional. You have to show discriminatory purpose. So the county naturally moved for reconsideration of this judge's decision, which had just been decided 5 days earlier, and he, of course, was required to reverse his decision, because the Supreme Court said in the Mobile versus Bolden case, that's not enough. This overwhelming evidence that you've got is not enough. So now we've won the Edgefield County case twice and lost it twice. At that point, we realized somehow, I don't know how, maybe just looking through the papers and trying to figure out something, we realized that the county had in fact made a change, a voting change after 1964 that had not been pre-cleared. There was a technicality because they made two changes. They pre-cleared the second one, but they forgot to submit the first one. So we said, well, we think that's a Section 5 change. And we went ahead, and the three-judge lower court in South Carolina ruled against us, saying the preclearance of the second change, and this is sort of technical, saying the preclearance of the second change sort of overtook the first change, and therefore it covered everything. We took that to the Supreme Court, and we won that case in 1984, which was the third time around. And finally, after that decision, the county went to district elections. In the first election after that, 3 blacks were elected out of the 5-member county council. Since that time, sometimes there have been black majority, sometimes white majority. The county manager chosen at that time was one of the people who had led in the case. And so it really was a revolution in Edgefield County that only took 12 years to get to.
I know that you were directly involved in the amendment in 1982 to the Voting Rights Act. Could you share that story with us and the purpose of the 1982 amendment?
I've talked a number of times about at-large elections, because at-large elections were one of the main instruments by which the South kept blacks out of office, and that means out of political power, and it means black constituents had, as a practical matter, nowhere to go if they needed a street light or better garbage collection, that sort of thing. So it may sound like a technical thing to say at-large elections made a difference, but what at-large elections meant is that blacks couldn't get a toehold into the political system, and that meant black citizens couldn't really get representation. Okay, so in 1971, there was a challenge to at-large elections in Indiana. The Supreme Court, on the grounds that they were using at-large elections. The Supreme Court rejected that and said just because blacks don't win, that doesn't prove anything by itself. Okay. In 1972, then, I got involved in a case in Texas where there were at-large elections in San Antonio and Dallas. And we tried that case, trying to learn everything we could from the Indiana decision of the Supreme Court 2 years before about all the things they said hadn't been proved. We proved all those things in Texas. And in 1973, the Supreme Court issued a case called White versus Register, in which they said the kind of proof, the totality of the circumstances presented by the plaintiffs in San Antonio and Dallas shows that the at-large elections are unconstitutional and have to be dismantled. Okay, so that set the standard for a whole bunch of cases in the 1970s. Bolden, Mobile versus Bolden in 1980 said all those cases, not necessarily wrong, they were no good anymore. Okay? So the totality of the circumstances and the kind of proof about the racially polarized voting and the history, all that stuff didn't matter anymore once the Supreme Court said in Mobile that you got to prove purpose. So then we went to work in the extension of the Voting Rights Act to add an amendment to Section 2. And what we did was we amended the statute and added something, whereas Section 2 had formerly said something like discrimination on account of race is unconstitutional or is illegal, we amended it to say something like, if any practice or procedure results in race discrimination, it's illegal. And we explained the results test. The question is, what is a results test? Well, it meant you didn't have to prove purpose. It was designed to reproduce the totality of the circumstances that White versus Register had dealt with.
So now we have another seminal decision, and you become involved in a case called Thornburg versus Jingles, the court's first interpretation of Section 2 as amended in 1982. Revisit Thornburg for us and the continuing use of redistricting, including multi-member districts and vote dilution, the inability of black voters to effectively impact candidate election.
Yeah, well, Thornburg took what Congress had written with the statute, Section 2, and took some of the legislative history and interpreted. And basically, Thornburg accepted Section 2, accepted Congress's work. There was a debate among the justices. There were several different opinions about exactly how you reviewed or viewed certain pieces of it, such as fine points of the statistical analysis, but it basically affirmed and put a stamp of approval on the work of Congress in Section 2. One of the problems, of course, Section 2 is a lot harder to prove than the mechanism under Section 1. First of all, you have to bring the lawsuit, and the plaintiffs have the burden of proof, and there's just a whole bunch of ways in which it's different. But at least it was another mechanism, especially because Section 5 only dealt with recent changes, whereas Section 2 could deal with things that had been around for a long time.
If we're focusing on the movement itself, so that our understanding of the tripartite history of the movement can allow us to assess the present and shape our future of social, political, and economic rights, we could end here. But a part of our history has already been written in the Supreme Court's decision in 2013 in the Shelby County case. Because of the decision in Shelby County versus Holder, our conversation with a nationally renowned voting rights lawyer whose life has been devoted to the shaping of the Voting Rights Act and the jurisprudence that sustains and advances voting rights cannot end without your view of that holding. Can you share with us at this moment, as you look back on your history, how you feel about the Shelby County case?
I think it's a case of willful ignorance. Basically, what the case says is times have changed, okay? Although Congress, which includes 100 senators and 435 representatives, whose job it is to know what's going on out in the country, whose job it is to go among their constituents and to go back to the hometown and all the places where people gather, to the political meetings, to the schools, to the American Legion posts, and get a sense of what's going on. They decided in 2006 that the act was still needed and that there was still evidence of problems in the covered states.
And Chief Justice Roberts then writes about the idea of so-called, quote, equal state sovereignty. I know you take some issue with that statement and the court's reliance upon that concept.
He says, well, there are a lot of other states that are now having problems too. And how much difference is there between the southern covered states and the other states? And there's a principle of, what does he call it, state equality. There's no principle of state equality in the Constitution. The Constitution has one place in it where it talks about state equality, and that's when it says customs duties may not be different at different ports. That's it. There's no such principle. The state equality notion is something he stuck in to the Mudd case in 2009. And so in 2013, in Shelby County, he says, well, there's this principle of state equality, and he cites the Mudd case. Because the point is, yes, it's true there are problems in other states, but the fact is, every indication from Congress is that the covered states are still worse. And not only that, when the covered states went in, it was because of their atrocious records. And the fact that they have improved some doesn't mean that the problem is solved.
So you believe it's important that we subject the Shelby County case to continued observation and criticism in the same way we have done with Citizens United?
I think two things. First of all, a lot of things will be done that wouldn't have been tried at all. A lot of things that, for example, voter ID laws that wouldn't have been tried or wouldn't have succeeded in the past. And second, a tiny fraction of those bad things will be stopped because you can't sue on everything. And if you sue, a Section 2 case, which we'll get to in a minute, is a huge burden, which is why Congress passed Section 5 to begin with.
Armand, looking back at my notes from the Shelby County case, the majority makes it clear that the court's decision does not retreat from the provisions of Section 2, and that Section 2 of the Voting Rights Act remains intact and preserves the purpose and efficacy of voting rights. What concern do you have about this seemingly reassuring conclusion? Does the judicial commitment to Section 2 of the Act ensure the future of voting rights for all citizens that was the basis for all of the cases we've discussed in our conversation today?
Section 2 is not remotely a substitute for Section 5. A Section 2 case, especially if you read Thornburg versus Jingles, you get an idea. You've got to get expert witnesses. You've got to put tons of testimony on. It's a huge production for even the tiniest little thing, so that the average lawyer or group of lawyers can't do it. There are a handful of organizations that can bring a handful of cases. Most things will go by the board because there's no way to mount the attack. They're huge cases. They won't be noticed. A lot of things will go by the boards without people noticing them. The relief is years and years. And Justice Kennedy, in the oral argument, asked how many preliminary injunctions had been entered under Section 2. And I think the opinion may say something about the availability. Preliminary injunctions under Section 2 are extraordinarily rare, extraordinarily rare. Supreme Court seemed to think that, well, just file a suit and get an injunction, stop the election. It doesn't happen. So Section 2 is, it's not remotely a substitute for Section 5.
Mr. Derfner, it's been an honor to be with you today and to discuss your personal involvement in virtually the entire history of our enforcement of the Voting Rights Act. Your involvement included not just your advocacy before the federal three-judge courts and in the United States Supreme Court, and your testimony before Congress, but your personal commitment to the purpose and enforcement of the provisions of the Voting Rights Act. If the Voting Rights Act, as you believe, is truly to be the destiny of democracy. I'd love to end our visit with a thought that we shared early on. Your belief in voting rights as First Amendment rights. Scholars write that the civil rights movement propelled First Amendment jurisprudence. So in closing our conversation, share with me your new passion that we must begin to see voting rights as First Amendment rights.
The right to vote has been sort of sidelined by the Supreme Court. I mean, it is the most expressive thing we do, the most expressive way we petition the government. But the right to vote, it's not treated that way by the Supreme Court. And it is, as a result, restrictions on the right to vote are rampant. The right to vote is treated almost like the object of a game, and the problem is exacerbated by the fact that, and I think by the fact that our legislators have the full power and are deferred to in making the rules that keep them and their friends in office. And I think that, frankly, is unusual among Western democracies. I think we are one of the few democracies where the legislators make all the legislative and election rules. And the problem is that if the degree of respect we give to the right to vote is so limited that restrictions are easy. And the restrictions affect the outcomes. So if the right to vote were, for example, treated as a First Amendment right, it would be treated in a very different way. Money spent to affect or influence our votes, campaign finance, that's now treated as a fundamental, sacred First Amendment right. And you see the Supreme Court striking down virtually every restriction on campaign finance, on the money spent to influence my vote. Well, how can my vote itself be devalued or be valued less than that? If the right to vote were treated as a First Amendment right, then restrictions on it would be viewed very skeptically. Some restrictions are obviously necessary. I mean, if the polls are open on a given day, you got to close them at a certain time. So you close them at 7 o'clock or 6 o'clock or whatever it is. Normal restrictions have to be observed. And I understand that elections have to be regulated to make sure, as the rules go, that they're orderly and fair. But under that guise, the courts have allowed restrictions that aren't justified because they don't scrutinize those the way they would if the right to vote were recognized as a First Amendment right, or the way they do restrictions on campaign finance. So how can the money spent to influence my vote be treated as a treasure if my vote itself is trash?